Thank you very much indeed, Madam Deputy Speaker. And I'd like to make a statement about workers' rights when we leave the European Union. But before I do, Madam Deputy Speaker, since this is my first time at the Dispatch Box since his death on Friday, can I put on record my deep appreciation of the life and work of Lord Bhattacharya, a heroic figure in British manufacturing. Lord Bhattacharya's work attracted investments to which hundreds of thousands of working men and women owe their livelihood. A Labour member of the House of Lords, Kumar worked easily with ministers and indeed prime ministers from all parties for the benefit of people of the West Midlands and indeed the whole nation. Madam Deputy Speaker, the United Kingdom and this Parliament have a proud record of improving the rights of working men and women, from Shaftesbury's Factories Acts to William Hague's Disability Discrimination Act, from the minimum wage introduced by a Labour government to the national living wage brought in by a Conservative government. And while the EU sets minimum requirements in many areas of workers' rights and health and safety requirements, time and again Britain has been in advance of them and has chosen to exceed them. The EU Agency for the Improvement of Working Conditions ranks the UK as being the second strongest in the whole of the 28 member states, behind only Sweden, for well-being in the workplace. The UK offers 39 weeks of statutory maternity pay compared with the 14 weeks required by the EU. We've given fathers and partners a statutory right to paternity leave, something that the EU is now only just starting to consider. Our national living wage is one of the highest in the EU, and the Low Pay Commission that advises on it is widely respected. Because we have not in practice been limited to EU standards, there's no reason why we should not maintain this record of leadership outside the EU. The Prime Minister has given a commitment that Brexit will not be allowed to erode workers' rights. Nevertheless, some honourable members during previous debates have advanced the view that there should be a parliamentary mechanism established to monitor and to implement that commitment. The Honourable Lady for Great Grimsby introduced a private member's bill to that effect, and the Honourable and Right Honourable members for Bassetlaw, Don Valley and Stoke-on-Trent Central, amongst others, proposed an amendment to a previous motion in a similar vein. We've been discussing closely with members across the House, with trade unions and businesses, how we can turn this intention into law. So the Government is today publishing draft clauses for inclusion in the Withdrawal Agreement and Implementation Bill to put these commitments into law. There are two main features of the clauses. First, there will be a new statutory duty placed on ministers bringing forward a bill that affects employment or workplace health and safety, that they should certify before second reading of any such bill that it is compatible with the principle of non-regression that the Prime Minister has given. They'll be required to provide explanatory information to Parliament in support of that statement, which will have been drawn up following consultation with businesses and trade unions. This will ensure that while respecting and upholding the sovereignty of this Parliament, members of this House in future will be able to consider very clearly the compatibility of every proposed measure with the non-regression principle, to which the Prime Minister has given a commitment. The second aspect of the draft clauses concerns future EU legislation. Parliament will be given the opportunity, at least every 6 months, to consider any changes to EU workers' rights and health and safety standards in the workplace. This will be reported to Parliament through a document which has been subject to consultation, again with employers and trade unions, and which will be scrutinised by the relevant select committees of the House, subject to their agreement. The Government will be required to table an amendable motion on its intended course of action on those new EU rules. For example, the Government may set out that it intends to legislate to give effect to those commitments, or that it intends to give effect to them in a different way, or that it does not intend to give effect to them, setting out its rationale. There are a number of legislative proposals currently under consideration in the EU which have a deadline for transposition into national law, which would be after the implementation period. We would expect them to be put forward for Parliament's consideration under this new process. These draft clauses will be published in a command paper today, and they combine well our determination to honour the commitment that the Prime Minister has made, not to see workers' rights weakened, along with respecting the sovereignty of this Parliament. A similar framework will also apply to environmental protections as the UK leaves the EU, implemented through the Environment Bill. On the 19th of December, we published the draft Environment Principles and Governance Bill, the first part of a much larger Environment Bill to follow in the next session. The draft bill outlines our proposals to establish a world-leading body to hold the Government to account for environmental outcomes after the UK leaves the EU. The draft bill also requires the government to publish a statutory policy statement on the interpretation and application of 9 environmental principles, including the 4 contained in EU treaties. And the government will legislate to ensure that when future bills could affect environmental protections, a Minister of the Crown will make a statement of compatibility to Parliament and provide explanatory information. We'll also create a new statutory duty on the government to monitor any strengthening of environmental protections and regulations by the EU and to report regularly to Parliament about the government's intended course of action in those areas. This will give Parliament the information it needs to consider whether or not domestic protections need to be strengthened accordingly. Through these commitments, the government will provide a robust framework for maintaining and strengthening environmental standards as the UK leaves the EU. In addition to these measures that I've described, I'm also announcing today steps that will strengthen the enforcement of employment rights. The vast majority of businesses operate fairly and treat their employees well. But I've been concerned, and I know many members of the House have been, about the practices in a small number of firms, in a small number of industries, where abuses of the conditions at work are used to the detriment not just of workers, but of reputable competitors who suffer a disadvantage by comparison in those industries. So I intend to consult broadly on establishing a new body to bring together the relevant enforcement functions of the Gangmasters and Labour Abuse Authority, HMRC and the Employment Agency Standards Inspectorate. As part of the forthcoming spending review, we'll consider what level of funding is appropriate to ensure that it is adequately resourced to deliver a strengthened remit. Madam Deputy Speaker, the measures that I've announced today reflect a process of engagement across this House and including with employers and trade unions. Not everyone will agree with every proposal. But if, as I hope, an agreement can be reached on the withdrawal process during the days ahead, it serves as a helpful guide as to how we might find and act on common ground across the House in the next phase of the negotiations. And I commend this statement to the House.
Shadow Secretary of State Rebecca Long-Bailey.
Thank you, Madam Deputy Speaker. And I also put on record my sadness and deep appreciation for Lord Bhattacharya and his devotion to British industry and politics. Now, I must start by thanking the Secretary for his engagement with me over recent weeks and indeed with trade unions and my parliamentary colleagues whom he's mentioned already, the Honourable Member for Great Grimsby, the Right Honourable and Honourable Members for Bassetlaw, Don Valley and Stoke-on-Trent, who've unrelentingly championed the protection of British workers as we leave the EU and continue to help us move the position across the House to one that we're all content with. But as he knows from our discussions over recent days, sadly the proposals as drafted don't yet provide full guarantee nor assurance for UK workers, and I do hope that this spirit of collegiality will continue and that we'll work together quickly to address my concerns and provide the changes and assurances that I seek. Now, as he knows, the TUC have stated today, in the face of a government determined to reduce rights, these measures would in no meaningful way compensate for the loss of the protections that currently exist. The assessment of less favourability will be decided by parliamentary majority and not by the objective standards of the UK courts. The provisions can be easily revoked by a hostile government, and even without being revoked, they can be rendered fairly meaningless in practice. Indeed, the content of the proposed statement of compatibility and a regular parliamentary assessment of less favourability are not actually capable of legal challenge by any UK worker as drafted. Now, of course, the process outlined in the draft clauses could be, of course, subject to a judicial review, but simply issuing a statement and laying a motion are hardly rocket science. But what will not be possible, however, is a challenge to the contents of a statement of compatibility or an approved parliamentary motion to accept a government assessment. Now, I think the Secretary, in his statement, implied that we should not automatically accept favourable rights solely because the UK Parliament has already set higher standards of employment rights. And on that point specifically, let me be clear, no one, certainly none of the colleagues that I have spoken to, is seeking anything other than that UK workers should be entitled to no less favourable rights at work than their EU comparators, not that we should accept unfavourable ones, a point which is very simple to draft and could be made perfectly clear, and I'm happy to work with the Secretary on this point. Now, of course, Parliament is, of course, always welcome to give more, but history has been littered with examples of the UK bitterly resisting EU directives on workplace rights. In the case of the Working Time Directive, it was a Conservative government which sued the EU Commission, claiming that there was no legislative base for the directive since working time had nothing to do with health and safety at work. Luckily for workers in the UK and the rest of the EU, it lost. Now, on the promise not to water down existing rights and protections, even if a bill is found to be incompatible, there are at present no powers to stop the government proceeding. Neither does the promise apply to secondary legislation, causing existing EU-derived rights potentially to become watered down with ease. Given the bulk of EU legislation within the UK to implement EU law is actually by way of secondary legislation, and I give the examples working time regulations, TUPE, health and safety regulations, just to name but a few. On the process relating to adopting future improvements in EU legislation, the proposals are equally in need of address. The only means of challenge is in Parliament, an amendable vote subject to the government's majority. Parliamentary procedure may not permit sufficient amendments to actually deal with all the additional changes to workers' rights identified by MPs. And in any event, resolutions of the House have recently proved to be an ineffective restraint on the government. Of course, the Secretary seeks to provide comfort by stating the government will consult with workers' select committees and employers' representatives, and that sentiment is, of course, welcome. But as he knows, there's no direct obligation on the government to accept any recommendations. Now, finally, Madam Deputy Speaker, on enforcement, I do welcome the commitments the Secretary has made to address the issue of funding deficiencies, and I await further details in due course. On the 1st of April 2004, there were 1,483 HSE frontline inspectors. By 2015, this had fallen to 972. In consequence, the statistical average workplace can now expect an inspection no more frequently than every 50 years. Madam Deputy Speaker, I've conveyed to the Secretary over recent weeks a guarantee of non-regression to be meaningful, truly meaningful, must be enforceable in the UK courts at the suit of any worker in the UK, and any dispute as to whether or not the worker has less favourable rights than her EU comparator must be determined by the courts and not solely by Parliament, still less by a politically motivated government majority in the House of Commons. Today's proposals come nowhere near this and do not yet demonstrate that the government takes workplace rights seriously. But I do hope, however, that in this spirit of cooperation, we work together to move towards more robust guarantees as a matter of urgency.
Secretary of State.
Thank you very much. Can I say to the Honourable Lady, I warmly welcome the tone in which she's approached this. I know that we come from different preferences as to what would be ideal, and that both the TUC and I think her own front bench would have preferred EU directives automatically to take their place in UK law and to be enforced through the ECJ as they are now. She knows that we disagree with her on that. In our view, it wouldn't be consistent with leaving the European Union or with the sovereignty of this Parliament. But I accept that that is her position, and what she has said is, notwithstanding that, we should explore whether we can meet the observations, perfectly reasonable, that she mentions. So I'm grateful for that. In terms of what we've published, they're draft clauses, and we're publishing them this afternoon. They haven't gone in the bill yet, and I'm open to working with all members of the House, of course including, continuing to include her, to see which of the observations can be accommodated subject to the approach, the general approach that we wish to take. I think she recognises, and members will recognise, that this is an important opportunity. If we are to pass a withdrawal agreement implementation bill, the chance to have from the outset on the statute book, literally within the next few weeks, I hope, some important protections for workers is one that I think we should all take. She asks some specific questions, and I'll attempt to answer as many as I can here. Of course, she makes an observation which is, in effect, that future governments, future parliaments may take a different view from that which we intend. It is a fact, as we know, that no parliament can bind its successor But what it can do is to express a clear intention and to set up a test and to provide mechanisms against which a proper scrutiny can be mounted of any proposal. And that is what we do here. And I acknowledge the contribution, in fact, the origination of this on the part of her honourable friends. She's concerned that the statements that are provided for could be ignored and may not be as effective as she intends. Clearly, the case law establishes that where there is a statutory consultation that is provided for, it can't be lightly swept aside. There is a requirement properly to engage with the recommendations that come from that. But I hear what she said about that being open to workers as well as people who might represent them, and we can talk more about that. She asks about the application to changes to workers' rights in the future that may come outside primary legislation. Clearly, the big changes do come through primary legislation, but in the spirit of what I said earlier, I'm certainly open to exploring what assurances we can give on other significant pieces of legislation that might be in scope. In terms of the jurisprudence of the ECJ that she mentioned, clearly it would be inappropriate for the ECJ after Brexit to have a remit in the UK. But of course, as she knows, as a lawyer herself, any court can have regard to the decisions of any court that it considers to be relevant in the case that they're considering. She mentions the matter of enforcement, and I think we strongly agree about that. There are industries, sometimes concentrated in particular places in our country, where I think what she describes is correct, that there is a calculation made that employers who abuse the rights of their workers are unlikely to be detected and enforced against, and that leads them to think that they can get away with that with impunity. The intention of the strengthened body that I set out today, and our intention in terms of resourcing it, is to firmly remove that from the minds of any such employer, and I will work closely with her on that. It is, I think, appropriate to recognise and to draw some pride in this House on our record of employment rights. We have a successful labour market. It combines a reputation for high standards, standards that have been recognised across the EU as being amongst the best in Europe, but at the same time having what is the most important right for workers, which is the right to work. And many more people are able to work in this country as a result of the effectiveness of our labour markets. So we need to preserve that whilst giving expression to the objectives that have been expressed by the Honourable Lady's colleagues to make sure that the commitment that we've given to build on that strength in the future is something that is not just a matter of words, but has parliamentary force behind it. And I'm grateful for what she said about working together.
Sir John Redwood.
I'm assured that the